There we go. Well, welcome. Hopefully everybody can hear us okay and see us. And I'm Attorney Peter Harbach.
I'm Attorney Sarah Cons.
And this is the first in a series of webinars that we're doing because of the quarantine. So hopefully we got good information for everybody. And thank you for coming and listening. Our first session is going to be on basically the disability documents that everybody needs to have in place in order to make sure that they're taken care of if anything were to happen, which, you know, given the circumstances of life these days, is more prevalent than ever and kind of more topical than we'd like it to be. But if anything were to happen to you, what you need to understand is that you don't have anybody who can just naturally under the law step in and make decisions for financial or healthcare things. You actually have to empower them yourself in order for them to have the ability to do what it is that they're going to need to do. And so what are those different documents that are necessary?
These 4 documents are going to include a financial power of attorney, a medical power of attorney, a living will, and a HIPAA authorizations. Or HIPAA authorization. And these really are the 4 tools that you want to have to make sure that you're empowering somebody other than you to step in and do things, whether it's making sure bills are paid and your taxes get filed, or whether it's somebody that's trying to advocate for you to get good medical care. Some of these documents you might already have, but you want to make sure that you understand what you currently have, how it fits with your current circumstances, and whether or not it's a good match for what you'd like to see happen in the event that different things occurred. So we're going to start with the financial power of attorney. Financial power of attorney is basically a document where you're naming a person to act as your agent and then giving them a variety of powers and authorities in order for them to act in that capacity. Now, if you have a current document, you want to make sure that you understand what powers and authorities you are specifically granting to your agent. You have to remember that you may or may not be available to speak on your own behalf as well. So if you are relying on your agent to be able to go in and go to the bank and withdraw funds or make sure that bills are getting paid, things like that, you are going to have your agent presenting this document to a financial institution. The financial institution is going to want to see specifically that you're authorizing this person to do exactly what it is they're trying to do. So you don't want a lot of general grants of authority where it says things like banking powers or business powers or contract powers. You know, what does that actually mean? You want to make sure you're specific about what they can and can't do. Can they access accounts? Can they get information? Are they able to write a check or sign a check on your behalf? Can they sign to file your taxes at the end of the year? You know, what are the things that they're able to do specifically? So when you're reviewing your own documents, make sure that you understand what you are and are not allowing them to do. Think about what kinds of things you have, accounts or property. Are those types of things referenced in this document? If they're not, that might be a gap in your planning that you should be aware of. You should also look and see what the date is on the document. With the financial power of attorney, your agent will find it's a lot easier to use if it's been signed recently. In the past 3 to 5 years, you're usually still able to rely on it being able to be usable. Once it gets older than that, it starts to get harder for them to use. It's not that the law says at this certain point it's no longer a good document. It's just that at a certain point, banks and financial institutions can start to get a little bit more nervous that you've signed a more recent version. So making sure you've had somewhat of a recent signature date can be important.
Yeah, and the perspective of the financial institutions is they want to make sure that they're not allowing anybody to do anything that they don't have the power to do. And so, as Sarah was saying, they want to make sure that there isn't a newer one out there, and they don't want to be granting authorities that aren't specifically listed because they don't want to be concerned that, oh, geez, we just let an agent do something that they didn't have the power to do. And so that's where being very explicit in the powers of attorney can be really helpful in making sure your agents have the easiest possible time in acting for you. Additionally, if you have any concern about long-term care expenses, either now or in the future, it's critical that your power of attorney actually provides powers that address those concerns. And what I might mean by this is I've had a lot of instances where somebody's suddenly, because of a health event, for the first time in their lives facing a transition into, say, an assisted living facility or a skilled nursing facility, and the family finds out what the actual cost of care is going to be. And a lot of times it's very surprising because they'd never looked into this before and didn't realize, oh, geez, this skilled nursing facility might cost $10,000 a month or more. Boy, that is going to go through the assets very rapidly. Is there anything we're able to do? And so inevitably, one of the children or a loved one hops on the computer and starts looking things up on Google and eventually finds the concept of, oh, what does an elder law attorney do? It seems like they help in a situation like this. Maybe I should go talk to one of them. So they call up, myself or Sarah or somebody from our office and say, hey, this is our circumstance. We'd like to sit down and talk to you. Well, one of the first things I want to see during that meeting is, okay, if mom or dad has lost capacity, let's see what that power of attorney says. Because it doesn't matter how smart I am or what kind of plan I can put together. If the power of attorney does not provide an ability to deal with long-term care, if it doesn't provide certain explicit powers, we're not able to enact anything I might come up with. And so that ends up being an enormous gap in a lot of people's plans. So if you do have concerns about long-term care, make sure that your power of attorney addresses and provides powers regarding those concerns. Because if you lose capacity and you're in that position and don't have those powers, the toothpaste is out of the tube and it's going to be really difficult to shove anything back in there.
You also want to make sure under the current circumstances that you understand when your agent is able to act. We've been hearing a lot of stories lately about people that are in quarantine, or maybe they're stuck in other countries or even just other states, and they're struggling to get back into their own lives. So they may be relying on friends and loved ones to help them make sure that things are getting done on their behalf. A power of attorney document can be active upon a declaration of incapacity. It can also be immediately effective. Declaration of incapacity usually means one or two doctors have evaluated the person and declared them to be incapacitated. So until that happens, your agent is not able to act. So if you just need somebody to step in and pay bills for a little while because you're in quarantine or because you can't get home to do so yourself, that document isn't going to be usable for your agent because you have to be declared incapacitated, and you're not incapacitated, you're just unavailable. An immediately effective document becomes effective upon signing. So that means as soon as you sign it, your agent has the authority to act as agent. You are not eliminated from acting for yourself. You can still do all of your own things, make your own decisions, which it would include firing your agent or changing their authorities at any time. But that it enables you to appoint them if you need them in a circumstance like this, where you're just not available, you can't do it yourself, and you need somebody else to act for you. So having an immediately effective power of attorney right now can really help to enable you to have somebody other than yourself be able to do things for you if needed.
Yeah, a good example of that is, the quarantine came on really fast. And let's say we don't get out of the woods, that the quarantine could be lifted, but it could be put back in place in the fall. There's a lot of talk about how there's a possibility of a second wave coming through, and I'm no doctor, I have no ability to assess how accurate that is, but let's say as a hypothetical that were to happen again, and it happened during a period of time where somebody's on a trip or not at their in their home state. Well, it might be incredibly important for somebody to have a power of attorney in place that's effective right now, so that the people that you trust have a position to be able to help you in a very timely manner and without a whole bunch of extra hoops in place. So, having a system like that, the two things that I'm looking for out of an agent are somebody that's trustworthy and somebody that can get things done in a timely manner. If you have an agent that fits the bill on those types of things, there's no reason to not create that agency right away. What's next on our list?
A medical power of attorney. So this is going to be a document similar to your financial power of attorney, because you're again naming a person to be your agent and then giving them a variety of powers and authorities that enable them to do so. This is another situation where if you have a current document, you want to make sure that you know what powers specifically you're authorizing another person to do. Your medical power of attorney, like I mentioned earlier, really should be your advocate. They should be making sure the care that you're receiving is appropriate for your circumstances. under the current situation, you're also going to want to make sure that the agent has the ability to do things over the phone or electronically, that consent can be obtained that way rather than in-person consent. Just because of the medical situation that we're in, doctors aren't always allowing people access to their loved ones if they do become ill. And it's difficult for them to advocate for you to make decisions if they have to do so in person. So does your current document address those types of things? If not, that might be something you should consider looking into. You also want to make sure that you're talking to the people that you're putting in as agents. There was a question that we've received asking about a similar circumstance to this. My parents haven't talked to me at all about their estate plan. What should I do? And this highlights one of the, unfortunately, gaps in a lot of people's planning. Those conversations are crucial to make sure that your agents and your loved ones know what it is that you want. If you're empowering them to do these things for you, how are they to know what it is that you want if you haven't talked to them? You don't want to rely on a document trying to explain what you'd want. If you name 100 different things, it's going to be the 101st thing that actually happens. What you want is them to be able to think back to the conversations that you had, talking about, well, this is what I'm comfortable with. This is not what I'm comfortable with. You need to make sure you have documents that are authorizing certain things and empowering certain individuals and are clear about that. But the conversations that you have with your loved ones, those are the pieces that make them feel comfortable in that role, that it's your voice that they're hearing when they're making these decisions, and that they don't feel like they're making decisions for you. They feel like they're just communicating your decisions to somebody else because you can't speak for yourself at that time.
Yeah, additionally, when it comes to, hey, my parents haven't talked to me about their estate plan, that's a problem. Because what they need to understand is people can't do a good job if they don't know they have a job to do. Whoever the acting agent is needs to understand they're the acting agent. These are the powers and authorities that they have. It's not uncommon that the parents maybe haven't shared anything about the estate plan. In fact, a lot of the older generation, the people that are in their 80s and 90s now, have a tendency to be very private, certainly about financial matters and things like that. And it's almost a taboo subject to be talking about this sort of stuff with them. Well, they need to understand that the estate plan itself doesn't necessarily require the communication of every penny you have in the bank or anything. They need to tell you where those accounts are, not necessarily how much is in them. That can be found out if needed later, but where did they do the different financial business at? What property do they own? And then where are copies accessible of this estate plan? Because if they're kept in some safety deposit box that only they have access to, how in the world is that going to be helpful to the family if and when there's a disability or somebody passes away? They need to have easy access. They need to know that they're in the right role, and they need to know what it is that they're in charge of. And so that can only be done through some amount of communication. And so there's no time like the present to start having a conversation. Does this stuff exist? Where can I get access to information? Am I an agent on anything? Do I have a role to play? If not, who is it? Who do I turn to if the circumstances change for you?
What other professionals might be involved? In all the documents that we create for our clients, one of the things that we include is the instruction to contact us in any emergency so that questions can get answered and the family can get guidance if need be. Even if it's not something that we do specifically, we can connect them with a resource that can provide some of the information. Honestly, in emergency situations, access to information and answers to questions are the most helpful thing that you can give your family. So having people that they can call upon to figure out what is it that they're supposed to be doing can be invaluable to the family in any sort of emergency. You also want to consider having either copies, hard copies or electronic copies provided to some of the people that you're naming in these roles. Having those conversations and then giving them access. If you're expecting them to be able to step in, they may or may not be able to access your house, especially under a circumstance like we're in now. ensuring that they have some method of gaining access to these documents ensures that the people you want will be able to function in these roles when called upon to do so. Making sure the documents themselves say that an electronic copy is as valid as the original, clarifying that you intend both to be able to be used. One of the things that I also recommend with my clients is family meetings where they bring their families into the attorney's office and we sit down and walk through their planning. What is it that they've done? What documents have they used? Who's doing what, roles and responsibilities. Even if we're not talking about amounts of money, we're talking about who's stepping into different roles and what questions do they have. Managing expectations. It's the surprises that your families encounter when they either are stepping into an estate administration or even if they're stepping in at a time of disability. Any sort of surprise or confusion, that's what creates the family conflict. So avoiding that, or to avoid that, making sure that you're communicating with family members. One of the things that I recommend to loved ones is see whether or not in this case, parent, whether or not they're willing to do a meeting with your attorney where they might be willing to sit down and walk through the documents that they have and assure them, I'm not looking to get information about money or amounts or anything like that if that's not something you're comfortable doing at this time, but maybe we can set up a meeting with the attorney to walk through what your actual documents are. So in case there are questions, we can get answers to them now when we're not under any sort of stress or emergency.
So what's our next document?
The HIPAA authorization. So a HIPAA authorization is probably a very common document to just about everybody at this point. HIPAA authorizations are very commonly used at doctors' offices so that they can communicate protected health information. Usually they're using these things to bill your insurance company because that's technically communicating your protected health information to somebody else. So they need to have written authorization from you to do so. You can also use these personally so that you can enable certain individuals in your life that you want to have access to medical information or access to a doctor. If there's an emergency, and you want your family members to find out what's going on, a HIPAA authorization can be incredibly important to them because it's their lifeline. It's their access to information directly, whether or not you are going to be available yourself. Sometimes with certain types of conditions, you can't have cell phones on in certain parts of the hospital if you're able to be in the hospital at all. So again, that access to information sometimes has to happen electronically. Under our current situation, you also have to be aware of, if you have current HIPAA authorizations, I've had clients come in and say, well, I already have HIPAA authorization signed at my doctor's office, and I listed my spouse, I listed my kids, it's fine. Well, you also need to be aware that that document might not travel with you if you're going to be going to a different hospital. Maybe there isn't room at the hospital that you would expect to go to, and you have to be transported elsewhere. Or maybe the condition is significant enough that you may necessitate a different type of care at a different facility. Those documents don't just travel with you. You want to make sure that your loved ones have documents that they can present at any medical facility that allows them access to information, again, answers to questions. So HIPAA authorization that you list all the individuals that you want to have access to information can be incredibly important. You want to make sure that you're at least including the people that are named as agents on your medical power of attorney. Your medical power of attorney itself should reference HIPAA as well. Obviously, your agent can't make decisions if they can't get information, or at least they can't make good decisions. But enabling them to have a separate HIPAA authorization backs that up. And again, having access to them for the people that you have listed is incredibly important in emergencies.
Yeah, and you should also know that every legal adult, HIPAA applies to them. And so that means every 18-year-old, absent a HIPAA authorization, they're the only person who has access to their own health information. So if you have children or grandchildren who are legal adults, but maybe not at an age yet where they've been thinking about their own estate planning. I mean, I'm not sure about you, but every 25-year-old I've ever talked to is immortal. And nothing's ever going to happen to them.
Absolutely.
And so they're certainly not focused on estate planning themselves. You should be aware that, boy, it's important to get these waivers in place because there's certain circumstances like the quarantine now where people can't get into hospitals or nursing homes in order to get people to sign documents. So having this stuff in place before they become necessary and are needed is critical. So HIPAA applies to everybody, and it's one of those overlooked things that can cause a lot of stress on the family if it's not taken care of appropriately ahead of time. One of the most striking things that happened in my career is about a year ago, I had a client who came in, and the sole reason he got motivated to do his estate plan was the fact that he had a coworker whose 19-year-old son had been in a car accident. And it took that family 3 days to find out any information about what it was that was going on with this person, because he was 19, he'd never done any planning, he didn't have any waivers signed, and so the family had no access to information. And he said, boy, I'm not going to allow that to happen to my family. I'm going to make sure that everybody gets this stuff in place. So what's our last document?
The last document on our list is a living will. A living will, very simply, is a statement about whether or not you want to be maintained on life support. This is often the backup for your power of attorney agent, this under the medical power of attorney. You don't want them reading this document later as the method of communicating your wishes. You want to have done that in advance, in person with them. But your living will can be your final backup. So to clarify what it is that you would or would not want, whether or not you'd want to be maintained on life support if you were in a permanent vegetative state. Having that clarification in writing can become helpful to you and to your agent. If down the road, the agent is trying to advocate for you and remove life support because that's what you've indicated you wanted, and maybe another loved one is misinformed and they don't realize that is what you'd want, and they're disagreeing with your agent. Although your agent still has the authority to make decisions, it can remove any sort of conflict or indecision among your family by having something in writing that clarifies your wishes, that can be shown to other people if necessary. It's also the ultimate way of communicating your wishes. If your agent just doesn't feel like they can do it, they can't remove life support just from an emotional situation or because of how they feel about what it is your choices are, they can present your living will and allow you to speak for yourself. So it can be important in communicating. It can also be important in making sure what you want is what actually happens. These go back to those important conversations that you're having with your loved ones, but ultimately the documents need to be accurately reflecting what choices you've made as well.
Yeah. And so each of these things need to be put in place, because this is how you say, well, you still have capacity. These are the people I trust. These are the powers that I give them. And so then there's not need for the court system to be involved. If you don't proactively put this stuff in place and provide all the rights, powers, and authorities, the family can be stuck in guardianship court, which I've never had a family who was in that position that felt like, boy, I'm really glad we're here. And so that process basically looks like, okay, we don't have these things in place, so we're going to petition the court for these authorities. And the court takes this very seriously, as they should. And they're stepping in without any information. The court doesn't know your family from any other family. And so they want to know that, okay, this person is disabled, and they're going to vet whoever it is that they might be putting in charge of things. And so this can be both time consuming and expensive, especially if the family doesn't agree about who it is that ought to be in charge. And so ultimately the decision is left up to the judge, and they're going to make the best decision that they can given the information that's presented to them. But one of the issues becomes, a lot of times, the reason for this guardianship is a decline in health that is now causing long-term care expenses. Well, you're not going to be able to, in most circumstances, get any powers from the court system in a guardianship that are going to help stretch out that person's money for a long-term care need. And so just when you need a power the most, because you're in the situation of having these expenses, your hands are the most tied because you can only do what it is the court allows you to do. There's also some overhead and some time involved in this court on an annual basis. You have to be doing accountings and certain things you need permission from the court to even do. They won't just give you the power to deal with it on your own. So it's much simpler and quicker to say ahead of time, okay, I trust these different people, so these are my agents. I provide them the different powers. And oh, by the way, if I face nursing home or long-term care costs, they have the authority to handle these things. Then there's no need to be in a court system. And it can be much, much smoother. So I'd really encourage just every adult, 18 and older, you got to get on the ball and get this stuff. And, I think the pandemic is really making people realize, boy, there's a lot of challenges. If I get sick and my family can't even come see me, I got to have this stuff in place because I may not be able to get it in place later. So I think we should switch gear and answer a couple of questions while we still have some time. We were able to address a couple of them so far, but I've kind of neglected one group of them because they're very complicated.
Well, I think we can start with the first one that we have here. The question has to do with what do you do if you have children that are US citizens, but you yourself are not a US citizen.
Mm-hmm.
So under the current circumstances, a lot of this goes back to exactly the documents that we've been talking through. Making sure that if you are trying to access information on what's going on, you want your children to have documents that enable communication and even decision-making to potentially happen through the people that they have named. You also want to make sure that you have talked through who your agents that are citizens might be as backups. So if you're having any trouble, having either backup agents or even co-agents, so you have more than one person that are authorized to act, that's spelled out in what exactly it is that they've signed.
Yeah, and it's a little unclear from the context whether or not the non-US citizen people here live in the United States or are domiciled outside in maybe the native country. But just very briefly, there is a number of different tax considerations. If the person is a citizen and has property outside of the United States, they're going to want to coordinate with an estate planning attorney in the jurisdiction that they're from, because those rules are still applicable. There is also probably a need to make sure that you're not creating foreign trust tax status, depending on where this property is and who it is that you might want to be managing this property. So you probably are going to want a US trustee, which the kids would qualify as. So it's actually, that's a very in-depth question that can take a lot of time to answer. And it's based on a certain number of circumstances for the person. Generally speaking, though, all of the documents that we were just talking about, the powers of attorney for finances and healthcare, if the person does live in the United States that we're talking about, they should have those in place, US citizen or not. That's irrelevant. If they're properly executed in the state that you're presently living in, then they're going to be valid. And there's this thing called the full faith and credit clause of the US Constitution, which means that if you validly execute it in one state, it will be honored in other states if you're either there or actually move there.
Or if you're, Wisconsin has a lot of snowbirds that if you aren't from Wisconsin, snowbirds are people that tend to fly south through the winter. So they might have a property in Arizona, New Mexico, Florida. So some of those people are actually quarantined there rather than here in Wisconsin. So making sure that your documents work in both places. It's always good to have attorneys that practice in the jurisdictions where you may have to use them, have reviewed the documents. It's always good practice, whether it's multiple states or whether it's attorneys from different countries.
And a second part of the question regarding the US citizens or non-US citizens was if you had a basic estate plan in place with one attorney and then you need to do more detailed planning, does that necessarily need to replace the prior planning, or how does that sort of function? And the answer is sort of a classic lawyer, it depends kind of answer. So it depends on what you've set up and what it is that you need to set up to properly address your circumstances. In a lot of instances, when you're doing an estate plan, it's sort of you want to make sure that everything fits together well. You don't want to do piecemeal things. And so a lot of times it's actually more difficult to, hey, I want to maintain this will and then build things around it. Sometimes it's just easier for the estate planning attorney to start from scratch and build it so that it all unifies together. And now that's not necessarily every instance, but most planners aren't doing things like charging by the document, like, oh, you need, we'll leave your will so you get a $80 discount or anything crazy like that. I mean, it's a lot of times it's just built from the ground up together.
I've analogized it with my clients as it's like trying to put together a puzzle, but you're taking pieces from different puzzles. You're never going to end up with the right picture at the end of it. That's kind of the same thing if you're piecemealing documents. What you want is to have a cohesive plan. Make sure that it's comprehensive, that the individuals involved are not surprised by their roles, that the authorities that you have match what it is that you own. So it's easy for them to step into this role, that they know who it is to call upon if they have questions or if they need guidance at the time that they actually have to start doing this. You should also do regular reviews. I talked earlier about financial power of attorney documents, wanting them to be no older than 3 to 5 years. And that's true in general of your estate plan. You want to have it reviewed regularly. Make sure that whatever attorney you worked with has a review program so that you know how it is that you can get back in and walk through them to ensure that what your circumstances are and what your plan is continue to match, because things change. People change, circumstances change, what you own changes, the law changes. You want to make sure that what you have still creates the right plan for you and your loved ones. Yeah. We also have a question on here that I know Peter has a particular passion for, so I'm going to let him address the answer to this. The question is, my dad wants to put his house in my name to protect it from the nursing home. What is the best way to do that? And honestly, that's the question we get all the time.
Yeah, I had that last week, and frankly, every week somebody's asking some variation on that question. And I should note that this is a running series of webinars that we're going to be doing, and I'm going to go into a much greater detail on this. So this is a very coincidental, timely question. But just to briefly give an answer on that, it's a terrible idea in most circumstances to just deed the house over to the child so that, okay, now they're the owner of it. That's a real common planning idea, but in my opinion, a really terrible idea. It comes coupled with a whole bunch of problems, one of which is it's terrible tax planning. It's awful and almost always ends up creating a very substantial capital gains tax for the recipient, and it's totally avoidable. So when we do another class, is it the very next one that we're going to be addressing this?
No, I think it's the one after that. But I mean, okay. we will be talking about long-term care issues in each of the classes, just like we did today, especially when we were talking about the financial power of attorney. We're also going to have some resources that are actually specifically about the house and some of the dangers that we see in putting the house into the name of a child or other loved one as a resource.
Yeah, and so when we actually have time to teach that one as a class, because the answer, like I said, is actually kind of lengthy, we'll go into more detail on problems and solutions. In part, very often we're going to want to be looking at an irrevocable trust to hold the home. That comes with way less complications when it comes to tax problems and liability over the home and things like that. So,
and anything that you do for planning, you want to make sure that it enhances your control rather than completely eliminating it. And doing any sort of direct transfer of ownership, like putting the house in somebody else's name, is a complete loss of control on your part. So, I mean, control tends to be an important piece of everybody's planning, and maintaining that in every way possible should be one of the focuses of your planning overall.
Yeah. Do we have a recording link? There's a question about that.
There's too many places that we have questions, apparently. The recording link for, we will be providing this on our website. There's also, for all the people that attended the webinar, this is, I think, another good way to get this information. We will be sending out emails looking for addresses, because the first 50 people to register were able to get a book of ours that we've written on a lot of these topics. So in the email that gets sent out, we can provide a link to the recording of this, so you can review it again or share it with somebody if you want to. There's also going to be a couple of resources that we're going to make available electronically. One of them is a review of the documents that we've just gone through. So the financial power of attorney, medical power of attorney. For the person that asked earlier, how do I get my parents to talk to me about this stuff? These are pieces that maybe you can take with you to go through this with them. You know, this is something I received from an attorney's office about planning. Do you have these documents? Can I see them? Can we walk through them? So you might be able to use this as a way to spur on that conversation. The book can be a good tool for that as well. We're also giving you some information about estate planning, some of the dangers that we see. We often conceptualize estate planning as a pyramid, where we're trying to build the pyramid and making sure that we have a strong foundation that's centered around you, and that we make sure that we're taking care of your loved ones and what's important to you, and doing everything in the most tax efficient manner possible as well, obviously. So those resources will also be made available as well as soon as this webinar is over. So if you do want to receive the book, make sure that you respond with your address so that we can send it out to you. Our next couple of webinars, we've got one next week on Tuesday at the same time, Tuesday, April 21st at noon. Tuesday, April 28th is the third webinar, and also at noon. And then the last one is on a Wednesday, so Wednesday, May 6th. So the next two are on Tuesdays, and then the last one, we're going to wrap it up on a Wednesday. So hopefully you're going to be able to join us for all of them. Please make sure that you're also coming with questions so that we can make sure that we're addressing the information that you actually want to hear about.
Yeah. Should we answer that last question, or?
Sure.
Okay. We just got another question in the last minute here. If one has homestead protection, is it a good idea to leave it out from the family living revocable trust? In most instances, the answer is going to be that it won't matter that it goes into the revocable trust. It depends on the context of the protection that you're talking about, but I almost inevitably end up putting the property into a trust. The person still, generally speaking, is going to have the same bankruptcy protections. It's not going to cause an issue if somebody goes into a nursing home. Even if it did, you can always deed it out of the trust in that context. But you want it to avoid probate. That's one of the biggest things. One of the advantages of a revocable living trust. So in most instances, the house is going to go into a revocable trust. How much time it takes totally depend. The question is, how much time does it take to draft various documents when it comes to estate planning? It depends a lot on the circumstances of the planning. You know, how many different things are necessary. The person's asking about a qualified domestic partners trust, an ILET. Those are some of the more advanced planning techniques. So on average, that can take a little bit longer than like a will and basic powers of attorney. It's hard to say. A couple of months, probably, if you're doing a bunch of advanced planning. Without advanced planning, maybe a month.
For some of them are basic planning. I also do sometimes family plans for an entire family, where we do maybe parents with adult children, especially kids that are between the ages of like 18 and 30, where they may still be, looking to mom and dad to do a lot of things to help them, and that they still rely on them for support. Maybe not financial support, but that's who they're going to turn to in an emergency. So we do an estate plan for the parents, and then we do basic disability planning for all of the family members. So everybody ends up with a power of attorney document that name maybe the parents or each other as agents, that everybody has HIPAA authorization, things like that. So sometimes that can be a helpful thing to consider, especially at a time like this as well. We have created safe zones for signings as well. So don't think that you have to wait until the end of all of this. We are able to sign documents. Unfortunately, we don't fall within some of the exceptions for electronic notarizing, but we have created contact-free signing possibilities within our office. So we're still encouraging people to complete planning to ensure that they have things that they need, especially going into something like this.
Yeah. And for some amount of people, you might have more free time on your hands right now, and that makes this a good time to get on the ball and get that plan together, so that when things open back up, you can go out and do things you want to do and not have to focus on this kind of stuff while you're stuck.
Mm-hmm.
So hopefully you guys all found this useful, and if you did, please,
join us again next week.
Tune in again next week. We're going to have a totally different topic that we're going to cover, and hopefully you find that useful. I think we probably will go through basic wills and trusts, mm-hmm. and some of the planning techniques there. And then the one after that, I think we're going to dive into long-term care in depth, including why you don't just sign the house over to the kids. So again, thanks for tuning in, and hopefully you found this a good use of your time.
Thank you.